Hello, this is Brian D. Hill, the former news reporter of USWGO Alternative News. Justice for USWGO.wordpress.com. My family and friends operate this blog. I hate to have to tell you this, but the federal courts have engaged in insurrection against the laws of the land. They have engaged in ignoring the law, ignoring the Constitution. They are disrespecting and ignoring and not following the law, the laws of the land. And so, I hate to break it to you, but in the Fourth Circuit U.S. Court of Appeals in Richmond, Virginia, on August the 17th, 2021, they have thrown out my remaining appeals. And they waited for months after I brought in one of my petition for rehearing documents. I brought up L. Linwood's claims that judges and politicians are being blackmailed with child rape and murder. According to his tweets that my family showed me, and I printed those out, and it said that they pointed a gun at these judges and politicians and said to rape children, and it was on video camera, and they would be blackmailed for the rest of their lives. So after I brought up these allegations in the Fourth Circuit U.S. Court of Appeals, they waited a few months and then they threw out all my appeals on the 17th of August. So they have ignored the law. They are engaging in insurrection against the law. The Fourth Circuit U.S. Court of Appeals is a runaway court, meaning a court that does not have to follow the law. They don't follow the Supreme Court. They don't follow the Constitution. They don't follow the verdicts of the Supreme Court, the justices. They ignore it all. They do whatever they want. They do whatever they please. They have broken two different laws. The United States Court of Appeals threw out one of my appeals on the writ of habeas corpus, even though I based it off the ground of actual innocence of my charge of possession of child pornography back in 2013. I am innocent, and they refused to give me an evidentiary hearing despite showing a strong showing of innocence. And it's a violation of McQuiggan versus Perkins of the U.S. Supreme Court 133, Supreme Court 1924, 1928, 2013, and Bosley versus United States 523 U.S. 614, 1998. The U.S. Supreme Court is being ignored by the Fourth Circuit U.S. Court of Appeals in Richmond, Virginia. They are ignoring the law. And another law that they have ignored is that the Middle District of North Carolina and Winston-Salem and Greensboro, North Carolina, they have thrown out my claims that were uncontested. According to Local Rule 7.3, and they enforced this in my writ of habeas corpus 2255 case, I filed motions in that case, motion to vacate fraudulent begotten judgment or judgments. And it's based off of two different things. One, if I am actually innocent of the charge of child porn, then I have every right to request that that the judgment be annulled, that I no longer be convicted because I am innocent. And two, I am innocent if the federal prosecutor had engaged in fraud on the court concerning my guilt. And I had proven that because the government had 21 days to respond to the motions to vacate the fraudulent begotten judgments. Since the one concerns summary judgment or may concern summary judgment or default judgment, they may have 30 days to respond. They did not do that. They did not respond in any time at all. They didn't respond even a year after those motions were filed. But Judge Thomas David Schroeder, the dictator, the judicial rebel, an insurrectionist judge that refuses to follow the Constitution and refuses to follow the law. This judge has denied almost every one of my motions I ever filed before his court. He has denied almost every one of them, and he's disrespectful of the law. Under Local Rule 7.3, they said if I didn't respond in 21 days to the government's motion to dismiss, even though it's supposed to be 30 days for summary judgment, but regardless, they told me if I didn't respond in 21 days, that the government's contentions are undisputed. Now, the government didn't respond to my motions where I proved that the government, AUSA Anand Prakash Ramsawamy, Greensboro, United States Attorney Office, had defrauded the court every step of the way in my criminal case. They used Christy L. Burton, a perjurer. She lied multiple times before the court. So that testimony should have been impeached. It is a fraudulent probation violation. They convicted me on that probation violation. And in the other probation violation case, I was under carbon monoxide poisoning when I was charged with indecent exposure. Well, it was at nighttime. I had to get out of the house, and it was carbon monoxide poisoning. I didn't know until after I went to jail. And my family found out about this from Pete Compton, who looked at the chimney and said, I can't let this stay as it is. It is causing carbon monoxide in the home. So I was subject to carbon monoxide, and it led up to the indecent exposure charge. And I gave this evidence to the Commonwealth Attorney, Glenn Andrew Hall. He's refusing to accept this. I mailed evidence to Martinsville Police Department, the officers that arrested me for indecent exposure. I gave them this evidence, and they gave it back to me. Well, they gave it back to my lawyer. They said, they refused. They refused. And I had friends email the Martinsville Police Department, and they blocked their emails. One of my friends said that they were blocked. Martinsville Police Department blocked one of my friends from sending them emails with evidence that I was under carbon monoxide poisoning. So the Martinsville Police Department is on purposefully ignoring evidence that I was under carbon monoxide poisoning. They refused to drug test me. I told the officer when they arrested me for indecent exposure, a man in a hoodie threatened to kill my mother if I didn't get naked. I think I was drugged. The officer refused to give me a drug test. Yes, a lot of people don't want to get drug tested. I wanted to get drug tested. The officer refused to drug test me. Then he lied on an affidavit. Robert R. Jones of Martinsville Police Department. They lied under affidavits saying I was medically and psychologically cleared and refused to give me a drug test. He doesn't know if I was on marijuana, methamphetamines, cocaine. I could have been on any kind of drug, and they refused to drug test me. So that means one thing. Anybody could have drugged me because there were parts of my memory that was blacked out. And I was, and the officers didn't understand why I was out there either. They were like, oh, Brian was out there naked at night for whatever reason. Look, anybody that's usually found naked at night acting crazy, they usually get tested for drugs. They get tested for blood alcohol levels. Even my attorney, Renorda Pryor, brought that up at the hearing and said that, what did you check Brian's alcohol levels, Officer Robert Jones? And he's like, no, we didn't drug test him. We didn't check his alcohol levels. We never looked at his medical records. We didn't do anything. So he lied under oath. He lied under oath that I was medically and psychologically cleared. So I don't care if I get targeted for this. Martinsville Police Department needs to be punished for what they did to me. That they would convict me on indecent exposure. They would not test me for narcotics or drugs or substances. They wouldn't check me for carbon monoxide poisoning, which if they had done a narcotics test on me, they would have found my blood levels would have been bad. The hospital did record, however, that I was under sinus tachycardia, that I had multiple resting blood pulses of over 100 at dangerous levels. And that's someone who's exposed in a short period of time to carbon monoxide poisoning. I was exposed for months before I was arrested on indecent exposure. Months and months, which can mess up somebody's mental state. And so I defend myself legally to all the charges I was ever given, including the first probation violation where I had an autistic meltdown after somebody tried to send me a threatening text message saying, we will set you up with child porn again, Brian. You will be raped in prison. So I'd received threatening messages. I reported to Christy Burton, and then another time she sat there and said, "You will not text message anybody anymore, not your lawyer." And I had a meltdown, sitting in a chair, like right now. I was sitting in a chair, things were thrown on the floor, but, not towards her. She admitted to that. And she, and Renorta's like, people with autism spectrum disorder have these meltdowns. It is normal when they feel threatened. When I was getting threatening messages, I was under attack. So, and then she just comes in and Christy Burton starts making demands. And I'm like, and I was going to try to do insulin shot. She says, "No, go back over here." Renorta Pryor was bringing that up, that Christy Burton was acting like a bitch. And I will admit she was acting like a bitch. This probation officer was being a bitch. She refused to let me do my insulin shot. And then she lies to the court multiple times. And Judge Schroeder defends her and says, "I hit my grandpa." And then he also says Brian likes getting child porn. He loves getting child porn on a cell phone where I was getting threatening messages saying they were going to set me up. And I voluntarily called the probation officer and I told her, "Here's the cell phone. I'm getting threatening messages and somebody tried to send me child porn." I did not ask for it. It came to me unsolicited. And I reported it to my probation officer, gave her the phone, and the court ordered it destroyed this year, so they don't seem to want this to come out. They want to cover up the evidence that I was being set up with child porn. They're covering up the cell phone. They've destroyed it this year. So they've already destroyed evidence now, evidence that will prove my innocence. So the government's already engaged in obstruction of justice, one side and down the other. And so I have proven it, that the United States Court of Appeals has engaged in insurrection. Under Rule 7.3, the government did not contest my motions. It was undisputed. I should have been found innocent of my probation violations. I should have been found innocent of my conviction. And so this concludes the video. And my friends and family will show the proof. The proof that I'm innocent of my probation violations and I'm innocent of my wrongful conviction. But the Fourth Circuit ignored it all. The Middle District of North Carolina ignored it all. They ignored the law. They're engaging in treason. They're engaging in ignoring the laws of the land. A court of law is ignoring the laws of the land. This is Brian D. Hill. God bless America. Where we go one, we go all.